Hi. The fact that I'm able to record this video and you're able to see and hear the same itself discloses the importance of electronic gadgets. Digital footprints are here to stay, and judiciary cannot afford to lag behind while keeping pace with technology. Everything from a purchase of a book or a plot of land can be bought online. Communication is only through electronic means. Surveillance is through the use of electronic gadgets. Electronic devices are used for commission of crimes, right from detonation of explosives to using drones for carrying out attacks. This dependency towards electronic usage is so much that in the days to come, or for that matter even as on today, it's almost impossible to have any case which does not contain digital evidence in some form or the other. Therefore, the need to understand the concept of digital evidence, which is necessary to prove any case, be it civil or criminal. However, I am confining my talk to some of the requirements that a prosecutor should possess while presented with digital evidence to prove a crime. Hope this presentation aids budding young prosecutors to deal with digital evidence when presented with it. Prior to dwelling on this topic, it's necessary to understand the legal recognition of digital or electronic records as legal evidence. Electronic record has been recognized and explained under the Information and Technology Act of 2008. As per the Act, electronic records includes data, sound, image generated or recorded and sent or received in electronic form. The Indian Evidence Act permits the admissibility of electronic records. Therefore, not only does law recognize digital records, but also permits it to be presented as legal evidence. What are the types of digital evidence that courts are normally confronted with? Although electronic records can be categorized under various heads, for legal purposes, we can categorize it under three heads. The first category would include compact disc, DVD, hard drive, memory chips, pen drive. Now, this kind of electronic records are admissible as primary evidence as well as secondary evidence. By primary evidence, we mean the original media which was self-generated and created without any human intervention. Secondary evidence is nothing but the copy of the original and has to be supported by a mandatory 65B certification under the Evidence Act. The second category of electronic records are audio and video recordings. Original audio and video recordings are accepted as a valid source of evidence. Tape recordings are recognized as res gestae, meaning they are considered relevant and also admissible in evidence. Admissibility of tape records is settled long before in multiple case laws, and they are taken as documents under Section 3 of the Indian Evidence Act. However, audio tapes could be altered, erased, and re-recorded, and there are certain factors that have to be established prior to relying on them. Now, these factors involve establishing voice of the speaker, its accuracy, relevancy, exclusion of the possibility of tampering or manipulation, that it has been obtained from appropriate custody, and clarity of the audio in question. If all these 6 factors are satisfied, then audio recordings are admissible and reliable. So far as video recordings are concerned, they hold the same evidentiary value as that of audio recordings. Video recording could be in the form of media file generated by a handicap, or it could be in the form of a CCTV footage, but there can be no doubt pertaining to its admissibility. When a video recording is to be submitted in a court of law, it can be submitted as a primary evidence if the memory chip along with the video camera through which the file was generated is tendered in evidence. In case the primary evidence is not available or is not practically possible to be submitted in court, a copy of such video recording created through a computer program is admissible as secondary evidence subject to conditions mentioned under Section 65B of the Evidence Act. What would be the position if an accused disputes his identity in a video recording? Now this is very possible. It could be possible that the accused covers his face with a scarf, a cap, helmet, or for that matter a mask while committing a crime, and later disputes that it was not his image in the video recording. Under such circumstances, it is necessary to establish the identity of the accused, which can be done through forensic science. There are scientific officers in the anthropology division, and they use the morphology technique for the purpose of comparison. They would compare the digital records with the photographs, and then they would give a report indicating whether the accused is the person caught on the camera or not. A third species under this second category is evidence admissible through video conferencing. This technology is what has gained immense popularity and is important in the present day. With the COVID-19 pandemic creating havoc, the only way through which courts are able to dispense justice is through the use of video conferencing. It's now settled law that even evidence is permitted to be taken through video conferencing, either by the court directly or through the appointment of court commissioners for that purpose. The third category of digital records: evidence in the form of emails and calls generated through mobile phones. Now there is a presumption under Section 88A of the Evidence Act which the court follows while taking emails as evidence. This presumption is only pertaining to the data fed into the computer and not in relation to the originator of the email. Email is well recognized as a valid source of evidence. Similarly, mobile phones can be a very useful resource when it comes to evidentiary value. Mobile phones can be used for the purposes of tracking location, to obtain call records, and submitting medias like pictures and videos recorded in it. It is with this backdrop that I intend pointing out the essentials that a prosecutor should possess when presented with digital evidence, which is part of the charge sheet. When confronted with digital evidence, a public prosecutor will have to have knowledge of 12 essential aspects. They will need to know, number one, how does the digital evidence in question work? Now take for example a CCTV recording, a closed circuit television or video surveillance. What are the components that it is made of? A CCTV would be made of a camera, a cable, a security DVR, a BNC connector and a power supply. Similarly, a handycam consists of a camera section and a VCR component. The camera section receives visual information and interprets it into electronic video signals, which is then recorded in the VCR. Therefore, there is a need for a prosecutor to understand the nature of digital evidence before presenting it to the court. The second important aspect for a prosecutor should understand what is the importance of the digital evidence to the case in question. Is it substantive piece of evidence or is it only corroborative? Is it primary or secondary piece of evidence? Is it conclusive proof or subject to supporting proof of assertion? Is the digital evidence inculpatory or exculpatory in nature? Now, when we say it's a substantive piece of evidence, conviction can be based solely on the basis of that evidence itself. Corroborative is nothing but supporting evidence. Primary is nothing but the original evidence itself, section 62 and 64 of the Evidence Act. Secondary evidence would be the copy of the original covered under section 63 and 65 of the Evidence Act. Conclusive proof, section 3 of the Evidence Act. If one fact is declared by the Evidence Act to be conclusive proof of another, the court shall, on proof of the first fact, regard the other as proved, and it shall not allow evidence to be given for the purpose of disproving it. Now take for example section 65b of the Evidence Act. It states that if the conditions mentioned thereunder are satisfied, then the secondary digital evidence shall be construed as a document which is under section 3 and shall be admissible in any proceeding without further proof or production of the original. In other words, the secondary digital evidence, when supported by a certificate under section 65b, will be in the nature of a conclusive proof, and there will be no need to produce the original digital evidence. Coming to inculpatory evidence. Inculpatory evidence discloses the guilt of an accused, whereas an exculpatory evidence exonerates the accused. Take for example a CCTV footage which discloses the accused committing the crime. That is an inculpatory evidence. Similarly, the CCTV footage does not disclose the presence of the accused himself. Then it becomes an exculpatory evidence. Therefore, this is the second important aspect which a prosecutor should be aware of. That is, the importance of digital evidence with regard to the case on hand. The third important aspect, the prosecutor has to ascertain whether adequate safeguards have been followed while seizing the digital evidence. Has there been a proper mahazir drawn? Have independent panchayats signed it? Has there been a proper preparation of proper property forms while seeking permission of the magistrate to retain the digital evidence? Section 100 subsection 3 of the CRPC, it mandates securing panchayats while conducting search. However, section 102 of the CRPC, which comes under miscellaneous, it does not mandate securing panchayats while seizing materials. However, it is always desirable to follow the best practice rule, and it is advisable to have panchayats even at the time of seizures. The fourth important aspect, if there are any guidelines issued by the constitutional courts regarding preserving digital evidence in a certain manner, then the same has to be meticulously followed. Now take for example in Karnataka. In Karnataka, in the case of Madhukara, which was decided on 2nd November 2018, there have been 10 guidelines issued regarding preserving the digital evidence. The prosecutor will have to take note of such guidelines and ensure that it has been duly followed. The fifth important aspect for a prosecutor is to consider whether, if the digital evidence is in a secondary evidentiary form, then is it supported by the necessary certification as required under law? Section 65b of the Evidence Act. Here, there have been conflicting views with regard to the need to produce a 65b certificate. The conflict is on two aspects. The first area of conflict is whether there is a need or a requirement to produce the 65b certification itself. For example, if a secondary evidence is obtained from an adversary or an accused, then can the certificate be insisted or obtained? Will it not be violative of fundamental right guaranteed under Article 20, Subarticle 3 of the Constitution? That is, you can't compel an accused to be a witness against himself. Another scenario is when a secondary evidence is obtained from a person or a witness who has not made the copy himself. Then how can a certificate be insisted upon? Therefore, impossibility or impermissibility of obtaining the 65B certificate. This is one area of conflict. The second area of conflict is, when should the 65B certificate be produced? Whether mandatorily with the charge sheet, or can it be produced at the time of leading evidence? It is in view of these differences, as seen in the case of P.V. Anwar, which was a judgment rendered in 2014, a 3-judge judgment, and in the case of Shafi Muhammad, which was a 2018 judgment rendered by 2 judges, that the apex court has now in the case of Arjun Pandit Rao Kotkar referred the matter to a larger bench. Just prior to the lockdown, the arguments had just begun, and now we are waiting for the outcome thereof. However, as a student of law and in my own personal view, I feel that when a situation arises where it is impossible or impermissible to obtain a 65B certificate, then the evidence can be brought on record as a secondary evidence with the aid of Section 65 of the Evidence Act. Now, Section 65 permits production of secondary evidence when it is not possible to obtain primary evidence. So also regarding when the certificate is to be produced. If the certificate is not part of the charge sheet, I am of the opinion that it can be produced when leading evidence. We should keep in mind that Section 65B is only a procedural law. It's not a substantive law. A procedural law should aid dispensation of justice. It should not cripple it. It is said that procedural law is a handmaid of justice, not its mistress. Therefore, I am of the view that even if certificate under 65B is not part of the charge sheet, but is produced when evidence is led, the same cannot be considered an illegality. Now, this is insofar as production of 65B certification is concerned. The sixth important aspect that a prosecutor should take note of is to see whether the digital evidence, which can be easily tampered with, has it been supported by an expert's opinion. Section 45 of the Evidence Act. Now, you should note that if a digital evidence has been proved, then its evidentiary value can be much more than an ocular evidence. The reason is, if 5 people have seen an act of murder, the manner in which each of them would have perceived the same would be different. This is because each individual is different. One may consider that the accused looked like a cold-blooded murderer, whereas the other may look at the murder in a totally different narrative. There can always be an element of human error at the time of deposition. This could be due to passage of time, lack of sufficient honesty, or events that have occurred post the incident. But with digital evidence, we do not run this risk. Artificial intelligence has not reached the stage of logically or intellectually narrating an event. It merely will depict what transpired. Therefore, if the digital evidence is proved, it may be a better form of evidence than an ocular evidence. Therefore, whatever is required to be done to prove a digital evidence should be done meticulously. And this is where the expert's evidence will support the veracity of the digital evidence produced. The seventh important aspect that a prosecutor should note. The prosecutor will have to see whether the digital evidence has been properly stored, duplicated, or copied, and the chain of custody. Will it withstand judicial scrutiny insofar as procedure is concerned? Again, if there are guidelines issued, the same needs to be followed. In Karnataka, as I've already stated, in the case of Madhukar, November 2018, there are guidelines which are issued, which the prosecutors could take note of. The eighth aspect that a prosecutor should take care of. Prosecutors should see whether the precautions taken for presenting the digital evidence at the time of rendering evidence. Now, if a prosecutor needs to establish that the digital evidence is a substantive piece of evidence, then not only should the digital evidence be marked through the competent witness, it is also necessary to ensure that the witness speaks on the content of the digital evidence. Now, this can be through the Mahazar witnesses who has seen the digital evidence, or through a scientific officer of the forensic lab who has given his report based on the digital records. It could also be through the investigating officer. Also, it's important to notice that when recording such evidence, it is always desirable for the prosecutor to insist on displaying the digital evidence in court in the presence of the accused. This enables three objectives to be met in pursuance of a fair trial. The first objective, it would help to refresh the memory of the concerned witness. The second objective, the principles of natural justice being met with insofar as the accused is concerned. And the third objective, it will enable the court to view the digital evidence so as to formulate the necessary questions regarding the contents of the digital evidence, which will have to be put across to an accused while recording his 313 CRPC statement. All these are so far as precautions which a prosecutor has to take while presenting the digital evidence. The ninth aspect. In the event a digital evidence is objected to at the time of marking, what are the aspects to be kept in mind to make it admissible? Section 61 to 65 of the Evidence Act. There are three stages through which a document, including a digital evidence, will have to pass through before it is held to be proved, not proved, or disproved. The first stage, when the document is filed in court as part of the charge sheet. Though at this stage the document is part of the file, it does not become judicial record. This is mere production. Now, the second stage, when the document is tendered in evidence by a party and the court admits the document, then it becomes a part of the judicial record and it would constitute evidence. We say that the document has been admitted in evidence. The third stage is when the document is held to be proved, not proved, or disproved. This happens when the court is called upon to apply its judicial mind with reference to Section 3 of the Evidence Act, and usually this stage arrives at the hearing of the final arguments of the case. This stage is called the proof of document. During the first stage of production or the third stage of proof, there is no much ambiguity and the procedure is quite straightforward and well settled. It's only in the second stage, that is regarding admissibility of a document, that problems arise. Most often, we refer to this stage as a mid-trial crisis. What will happen when there is an objection raised at the time of marking of a document? When a document is sought to be marked or exhibited, the objections that can be raised can be categorized under two major heads. Number one, inadmissible in evidence, that the document sought to be marked is inadmissible in evidence. And number two, the proof of document in question, which means the mode of proof of that document. The objections can also be categorized into minor heads, which includes the relevancy of the document in question and the genuineness of the document. I'm not going to deal on that in this talk. However, I'd say when the objection is of the first kind, that is inadmissible in evidence, the prosecutor will have to consider whether there is a statutory bar for admission of the document in question. Take, for example, a document being insufficiently stamped. Then under Section 35 of the Indian Stamp Act, the document cannot be marked. Similarly, a digital secondary evidence from a competent witness who is the author of the copy of the digital evidence. Then, if the Section 65B certificate is not produced, then the digital evidence is inadmissible in evidence. When there are such statutory bars which makes the document inadmissible in evidence, then the court will not permit such documents to be marked in evidence. But as regard any other objection raised at the time of marking of the document, be it regarding its admissibility, mode of proof, or its relevance or the genuineness, then, as per the ruling of a 3-judge bench in the case of Bipin Shantilal Panchal versus State of Gujarat, reported in 2001 3 SEC page 1, the trial court will not pass an order on its admissibility at the time of marking of the document, but would merely note the nature of objection and continue with the marking thereof. Bipin Shantilal's case was in the context of a criminal trial in an NDPS case. The only exception, as per this ruling, is regarding insufficiently stamped instruments which are inadmissible in evidence. In all other cases, it is only during the time of final hearing that the court will consider the objection raised at the time of marking and will give its finding on the objection raised. If the court is of the view that the document is inadmissible, then it will not consider that document while deciding the case. If it considers that the document is indeed admissible, then it will consider the same subject to it being proved. Now, this direction issued by the apex court has multiple advantages. 1. It would ensure that there is no delay during trial. 2. It will prevent adjournments and the witnesses will not have to be bound over till the finding on the admissibility of the document in question. 3. It will also ensure that there is no challenge to the interlocutory order passed regarding admissibility of document. This could be either by way of a revision or a 482 petition. And 4. Since the decision regarding the admissibility of the document is taken at the final stage and the finding is part of the final order, the higher courts can always relook into this finding when the final order is subject to challenge either in appeal or revision. While the court considers the determination of the admissibility of a document, the court will concentrate only upon the document. It will not be concerned with the proof of that document. The proof will be determined on consideration of the entire records, the oral evidence, and other corroborative documents. Also, it's important to note that the marking of a document will not dispense with its proof. So, a marking of a document cannot be postponed till the document has been held to be proved, and vice versa. A document cannot be held to be proved merely because it was permitted to be marked. The 10th important aspect that a prosecutor should be aware of: the need to get marked a digital evidence as an exhibit rather than a material object. Now, this is because at the end of the trial, a material object normally gets destroyed, and it is not in the case of an exhibit. The 11th aspect: how does a prosecutor confront a hostile witness or defense witness with digital evidence? Digital evidence is considered document under Section 3 of the Evidence Act. A prosecutor will confront a hostile witness with the digital evidence in the very same manner in which he would confront him with a disputed document. A witness may be hostile in view of either a defect in memory or in his honesty. If the defect is one of memory, then when he is confronted with the digital evidence and his 161 statement, the witness may recollect the event and may support the prosecution's case. But if the hostility is because of lack of honesty, then the attempt of the prosecutor is to confront the witness with the available digital evidence along with this 161 CRPC statement and try to cast a suspicion on the reliability of or veracity of that witness. This is to enable that the defense is not in a position to take advantage of the evidence of such a dishonest witness. Section 145 of the Evidence Act provides for confrontation of such hostile witnesses with their previous statements. Finally, the 12th important aspect. How would a prosecutor prove a digital evidence? Since digital evidence, as I've stated before, is considered a document under Section 3 of the Evidence Act, the prosecutor will have to prove the digital evidence in the very same manner in which he would prove a document. The prosecutor will have to display the digital evidence for the inspection of the court. If it is a video recording, he would play the video for the consideration of the court, and similarly, in case of audio also, he would play it for the court to hear the audio tape and see whether it supports the case of the prosecution. All this is permissible under Section 61 to 65 of the Evidence Act. Prosecutors will have to keep in mind that the judge's awareness, understanding, and application of digital evidence is largely dependent on how the prosecutor has put forward its case with the aid of digital evidence. Therefore, this added responsibility to first understand the concept correctly before placing his arguments on it. These are the 12 essentials for a prosecutor when presented with digital evidence. Now, although there are so many other incidental aspects that are relevant, such as the role of a public prosecutor at various stages of proving a crime, be it at the stage of investigation or post-filing of charge sheet. However, due to paucity of time, I will not dwell on the same in this presentation. I do hope that this presentation will be of some use to budding prosecutors when confronted with digital evidence. Hope we will soon tide over the pandemic days, dust out our robes, and come up refreshed and energized. Thank you.